All right, it's almost 6:35, so I think everybody should be here. So we're gonna get started. Hi, my name is Kaylee Romansky. I am a current member of public policy, and we want to welcome you in, in joining our public policy committee, family and equal pay training today. We're so excited. We were able to reschedule this from several weeks back when we had like a massive snowpocalypse happen on the day of our day at the Capitol and our planned GM to present all of this. So I know it was a letdown for a lot of us, but we're so excited for you all to be here to become more educated on these topics, to become kind of more empowered and have a more active voice in the workplace. So I am going to we're going to go over some Junior League updates to start, specifically some public policy.
Oh no, you're muted for me.
Have I been muted this whole time? just in the last second, a few seconds?
You're
Okay.
good.
Okay. Well, we are going to hand it over to Julia Scanlon. She's our lobbyist for the Public Policy Committee and our guru who knows everything there is to know inside and out about all the legislation that we are supporting. And we basically support, different pieces of legislation that kind of back our mission at different levels of support. So this is what we've been working on, and Julia can talk much more thoroughly about all of this to you than I can. So I'll hand it over to her.
Well, thank you for that wonderful introduction. And yes, it's been a very busy year for the Junior League Public Policy Council. So just to kind of quickly update you all on a couple of their key issues. Wanting to make sure you all know the depth and breadth of things that the league is looking at. I will say, maybe just for the sake of time, the active monitor bill we were looking at, exemptions for child products. The league has started kind of looking into different ways that we can address our mission of alleviating systematic poverty for women and children in the Denver area. This one was trying to look at how you could start addressing the financial burden that comes from having kiddos. So unfortunately, this one was going to be a really big hit to the state budget. So not going to go forward this year, but probably something that could come back in later years. The House and Senate are looking at a different kind of child tax credit bill aimed at lower income folks. So other measures in this sort of space are moving forward, but not this exact bill. The other bills that we're looking at, Senate Bill 32, methods to increase use of transit. This one was of particular interest to the league because within this program, if you've ever ridden RTD over the summer in the last couple of years, hopefully you noticed that usually in the month of July, you're able to get a free pass for transit during those high ozone days. We're trying to encourage folks to be not driving their vehicles, but why this was of such interest to the league, we're also opening up funding options for youth-free fare. So local transit agencies throughout the state, like RTD, will be able to either use the grant money that is coming from this bill for either their ozone-free fare days or to offer up free ridership for kiddos under, well, bigger kiddos too, anybody under 21 to ride public transit free year-round. So that was part of the impetus for our support. There were a ton of kids coming from DPS who are talking about the financial burden that comes from trying to get to and fro for any after school activities, jobs they might be having. So that one is one that we thought was important to support. The next one, House Bill 1237, Programs for the Development of Childcare Facilities, was kind of dubbed a child-friendly communities bill. So trying to partner with business and early childhood providers to give folks grant options for both converting spaces, non-traditional spaces to provide childcare, making sure that folks who are providing the early childcare have the best training possible, all kind of that good jazz around early childhood space. So that's sort of a legacy issue of the league. You all have definitely been supportive of things like universal preschool, universal kindergarten, free kindergarten. So we've done a whole lot in this space and continue to be interested in the affordable access to early childhood. Similarly, House Bill 1223, Improved Access to Child Care Assistance Program, is still in the works. I will say all of these ones, besides 1027, are in the works but close to being done. The session does end. I should have opened with this, but whoop, the session ends on Wednesday at midnight. So there's a whole lot to get done between now and then, but all of these are in a good place and moving through the process. To go back to House Bill 1223, just to put a pin in that one. There is specific state funding that goes towards lower income folks to have access to early childcare. This does a couple technical changes for access and increases the amount that's being funded. So we can move to the next slide. These are kind of our bigger issues, I will say. So kudos, we already have two bills that have been passed into law. The first, House Bill 1098, cause required for eviction for residential tenants. If you all were following the news, you might have heard about this one. It was kicked up kind of a bit of a fuss down here. The quick skinny, for the sake of time, the league supported the bill because often it is lower income folks and more often folks with kiddos who are facing eviction. So that was sort of the impetus for our interest. What the bill does in a really simplified nutshell is say that anyone whose lease is coming to an end or who hasn't heard from their landlord about renewal or might be facing eviction has to be told at least 90 days in advance if their lease won't be renewed or if they're going to use the property for something else. And I will say that the protections are only in place for folks who are in good standing. So you can't be, breaking your lease and being, very loud and disruptive or anything like that. So if you're a tenant in good standing, you'll have at least 90 days notice before a landlord is able to either have you leave the property or use the property for whatever else they want to be doing with their private property. So super important, quite the fight that the Junior League was part of a large coalition of voices for tenant protections. The next one, House Bill 1017, Bill of Rights for Foster Youth. I'd say this is more of an almost legacy issue for the Junior League of Fort Collins. Those folks have made foster youth issues one of their key areas. Basically, again, another weedsy one you might have heard about in the news, but basically there is a youth foster advisory group that requested that the legislature clearly lay out a Bill of Rights is what they called it, but specific kind of protections that folks, kiddos who are in the foster system have so that if they are having issues with foster parents or parts of the system, they know exactly what protections they have and they have to be told those, in a digestible way for kids, but still make it more apparent because there was just, no surprise. There's a lot of kiddos in the system with a lot of different needs and wanting to protect and make sure that those kids have some autonomy in the process. That one is already signed into law as well. These last three were all our level 1 issues, which means that the Public Policy Council asked the board to elevate these as our kind of biggest bills of the session. That means that we're actively testifying on the bills, asking for policy changes if needed, active lobbying, and then a lot of bugging of legislators, both in person during usually our day at the Capitol or emails, phone calls, texts, you name it. The first one, unfortunately, House Bill 1297, Baby Bonds Program Study, was a study to see the feasibility of the state offering a baby bond. So I know bonds have sort of gone out of style, but basically the concept was offering lower income kiddos a bond purchased by the state and managed by the state for the first 18 years of their life. So it can grow interest and accrue value. And then when kids turned 18, they'd have access to use the baby bond program towards housing or career development or college. It was basically looking into the feasibility of doing this. Unfortunately, between the really tight budget year and other priorities that sponsors were working on, this one is not going to be able to go forward this year. But the good news is there's definitely an interest in bringing this concept back next year. So something that the league can look in engaging with further down the road. Good news on the other two, though. House Bill 1431, Stable Housing for Survivors of Abuse program. This one basically was born out of consistent monies the state has towards any folks in the state who are survivors of sexual abuse or domestic abuse needing temporary housing. Unfortunately, during the COVID era, we saw a higher uptick of folks needing to utilize this programming. So basically, the bill is a department bill, so loved by the governor's office, basically says we need to always have a specific pot of money available for those situations and people throughout the state. The good news, this one got passed today out of the Senate, 30 votes yes and 3 no, and then 2 folks were gone. So bipartisan support all around, and it'll be headed to the governor for signature here shortly. So kudos, and thanks for, I know we had folks who were trying to make themselves available. That committee hearing last week didn't happen until 11 at night. So they had all the votes and they basically told everyone, you're fine to go home. We have all the bipartisan votes we need. We're good. So thank you, though, for folks who were interested and willing. Our last one, I'd say, has had the most difficult uphill, but not without a lot of effort on our end. House Bill 1164, free menstrual products to students. So it is like what it sounds. Basically, the bill requires, with sort of a long grace period within the next several years, all school districts throughout the state will be required to offer some form of period products in their school bathrooms. And they have a little bit of a ramp up period, but the JLD has a long history of supporting period equity and getting rid of the pink tax on period products. Melissa Boucher stuck around, was that Friday night, until I think you got there at 8 a.m. for a different junior league event and didn't leave till maybe 11:30. So you did a fantastic job testifying about the importance and equity for girls who cannot afford these products and therefore are missing school. So got out of committee with full support, which was a kind of a rarity. And then it'll be up tomorrow for final voting, and we're hoping we'll squeak through with a couple Republican votes. So that is kind of, and this is, I will say kudos to the entire Public Policy Council, because you also discussed on top of that probably another at least 25 or 30 bills. So busy year, lots going on, but a lot of important work being done down here. And certainly on those key level 1 issues, we have been very important and impactful with harassing people to make sure they know how important these issues are. So kudos. And I don't know that we have time for questions, but if you end up having questions, I'll throw my email in the chat in case anybody has anything you'd like to chat about. Okay. I'm not sure who's next, if I'm supposed to pass the mic. Sorry.
That's me. Yes. All right. Thank you, Julia. So we are going to get started with our lovely speakers who have joined us here today to tell us more about all things family leave, equal pay, all of that good stuff related to women in the workplace and knowing our rights. So I'm gonna just give a brief introduction to all of our speakers and kind of outline what it's gonna look like for the night. So we are gonna be first hearing from Louise Myrland and Ellen Giarratana. And is that right? Did I say that right? Ellen?
Yeah. Yes,
Okay.
Giarratana, good job.
Okay. All right, great. So we've got Louise, who is the Vice President of Programs for the Women's Foundation of Colorado, and Ellen, who is the Job Equity Program Manager at the Colorado Department of Labor and Employment, who helped efforts for equal pay and the Equal Work Act. And they'll be teaming up to share with us some background and the need for equal pay, general information and specific requirements and enforcement of the law. Then and in between each set of speakers, we're going to be having time for Q&A. So feel free to slip any questions that you have into the chat, and we'll be kind of following along with that and giving a few minutes to the speakers at the end to go through those and answer any questions that you might have. We're then going to pass it along to Kaitlin Altone, who's the senior organizer in the Colorado chapter of the National Association of Working Women, who's going to be giving us a high-level overview of FAMLI. She'll touch on important things to know in terms of rights, violations, and provide some context or background behind the need for this legislation. And then last but not least, we're going to be hearing from Diane Giarratana, who's the head of total rewards at the University Corporation for Atmospheric Research. I believe that's the one out in Boulder, who helps with compensation and benefits for the workers there. So she'll give us some practical applications of the FAMLI law from an employer and employee perspective, and will give us some good guidance on worker protections and how to talk about salary and what questions employers can and can't ask. All right, so we will start with Diane. Oh, wait, sorry. Start with Ellen and Louise. So again, Louise is the Vice President of Programs for the Women's Foundation of Colorado, and leads the research, public policy, grant making, and statewide community engagement efforts to advance gender, racial, and economic equity for 2.85 million Colorado women and their families. So in this role, she leads with trust and applies an intersectional approach to advocating for just, inclusive systems and investing in programs that improve economic opportunities for women of every background and identity. So her career is dedicated to advancing social justice, and this began in her science education and outreach prior to joining the Women's Foundation of Colorado in 2014. And so prior to that, she helped build the Denver Scholarship Foundation from its founding, and provided college access, affordability, and success programs that propelled Denver public school graduates to pursue post-secondary education. She earned her Master's of Public Administration from the University of Colorado, Denver, and her Bachelor's of Science in Chemistry from the Ohio State University. And she's lived in Colorado since 2005 and is raising her family in Denver. And we also have Ellen Giarratana, who is the Job Equity Program Manager at the Colorado Department of Labor and Employment. As I mentioned earlier, she made efforts for the Equal Pay and Equal Work Act and other hiring laws in Colorado, including the Job Application Fairness and Chance to Compete Acts. Before her work with the CDLE, she was the managing attorney for the Colorado Center on Law and Policy, where she advocated for the equitable enforcement of legislation, represented community members in anti-poverty litigation as well. She also drafted policy in coalition with organizational partners and community members for criminal record sealing reforms and updates to Colorado's equal pay law. Her career has centered on social justice and civil rights as a fellow focusing on criminal justice reform at the Southern Poverty Law Center, and an attorney who's specializing in employment discrimination and litigation. So that's a lot of information, but you guys have a great background. So we're excited to hear from you. So once you are ready, you can take it over from here.
Thank you so much. Thanks for the opportunity to be here this evening. I'm going to take just a moment and switch over the slides that we're sharing so that Ellen and I can share a little bit more about Colorado's Equal Pay for Equal Work Act. We're so glad there's so much interest in this and family this evening. There are good things changing here in Colorado, and the more folks who know about that, the greater the impact of these changing laws will be able to celebrate here in Colorado. My video is getting a little bit funny. I'm hoping that it's going to keep playing along with us. And Ellen, just want to make sure that you're seeing the slides that we're planning on sharing. Great. All right, so I think we're ready to go. And I imagine that part of the interest this evening about the Equal Pay for Equal Work Act is because we are all pretty familiar with how persistent the wage gap has been and how significantly this continues to impact working women across Colorado and across the country today. Based on the latest information we have, we know that when comparing women's earnings to men's earnings overall in our state, women are still earning only 81 cents compared to every dollar paid to men. This is why Colorado has needed to take significant action to change laws so that the bias that's created to this awful pay gap doesn't continue to impact women. Because we know that this adds up. Not only is it unfair when people are paid every paycheck less than they should be making, but this adds up to more than $500,000 of lost out pay opportunities over the course of an average Colorado woman's career. And we know also that the gaps are even wider for women of color. We're looking more closely at the earnings comparison of Black women, Latinas, in comparison to what white men are paid. We are seeing that the pay gap is really a wide gulf. Black women are paid only 60 cents on the dollar compared to their white male counterparts, and that figure is only 54 cents on the dollar for Latinas. This adds up to more than $1 million of earnings lost out due to the gender and racial pay gap over the course of women of color in their careers working here in Colorado. And I'm so pleased that we have so many of our partners here with Junior League, with Ellen representing her volunteer work with the Colorado Women's Bar Association, with Kaitlin and the team at 9 to 5 Colorado, as we were part of a large coalition of advocates that help to shape the laws that are really changing the trends here in Colorado and setting a better example for the rest of the country. And in many of these conversations, I had the opportunity to say, I'm not an attorney, and I'm so glad to be accompanied this evening by one of the best attorneys to talk about equal pay. So I'm going to hand it over to Ellen to share more about the specifics of the law, and then you'll hear a little bit more from me later this evening because we have some exciting updates and new research and resources to share. Thanks so much, Ellen.
Thanks. It's so funny because I really enjoy being in rooms with non-attorneys. So it's great that we get to work together. I just want to echo Louise in saying thank you for having us tonight for the CDLE and the Division of Labor Standards and Statistics. It's really important to us that we educate both workers on their rights in the workplace and also employers on what they can and cannot do in terms of job postings and applications. And so it's really a joy and a pleasure to be here. I'm going to focus on the substance of the Equal Pay Act and sort of how it's enforced and how that's going. So there's two parts to the Equal Pay Act. So you'll often hear advocates and attorneys in our division refer to Part 1 and Part 2. Part 1 is really the substance and meat of prohibiting unequal pay for substantially similar work on the basis of sex or gender identity. So I think that that's probably what most people think of when they think of Equal Pay Acts, the Federal Equal Pay Act as well. That's typically what you think of. There's other pieces of Part 1 that I'll also talk about that ensure that people are able to talk about pay and not feel like they are going to be retaliated against. Part 2 requires and protects transparency. So requires transparency in job postings, requires employers to announce job opportunities. And Part 1 is really important. And I think that a lot of It's getting a lot more attention recently, especially as states are starting to pass these laws. But I think that part two really has, over the past 3 years, done a ton to decrease the pay gap, and Louise will talk more about that. That's just the timeline quickly. This act passed in 2019, and I think it's really easy to just say, oh, it passed in 2019, but there was so much that went into it. It was years in the making of advocates, organizations like 9 to 5 and the Women's Foundation, the Colorado Women's Bar, legislators, all working really hard to get this passed over the course of many years. So I just want to acknowledge all of the work that went into this to get it passed. It was effective in 2021, and in 2023, there were some changes that were made, including just to make it easier for employers to understand, and workers as well, and to increase compliance in that way, as well as creating more enforcement, both with my division and creating additional remedies, or stronger remedies, I should say, if you prove your complaint under Part 1. So if you can go to the next slide. Focusing on Part 1, like I said, it's sort of the meat of it, which prohibits pay discrimination on the basis of sex or gender identity. You have to show that you are doing substantially similar work to a person of the opposite sex, essentially. And this is not just about job title. So if you believe, or someone in your workplace has the same job duties as somebody else, but they might not have the same job title, that doesn't really matter in this instance. It's really about the work that you're doing and whether it's quote unquote substantially similar to somebody else's. And everything else being equal, you should be paid the same. There are some factors that employers can rely upon, and I'm not going to get too into the weeds about the federal law, but part of the problem with the federal law, because I think a lot of people think, well, there is this federal law that's been in place for decades, so why do we need this Colorado law on top of that? And the reason is that the federal law really hasn't been very effective, because there's sort of this catch-all provision that employers can say, well, it's based on something else besides sex. And that they were able to rely on that. And so I think a lot of advocates and lawyers kind of stopped taking cases because they weren't able to win. So in Colorado, we really just have 6 ways that an employer can reason away why there is a pay gap between 2 employees. So the first 3 are a seniority system, a merit system, or a system that measures quantity or quality of production. And I think the folks who wrote this law, the really important piece of those 3 is this idea of a system. So it can't just be that an employer is sued and they say, well, it was based on merit. This person has more merit than this other one. They have to really have a system in place that demonstrates that they really truly rely on seniority or merit, or quantity of production. So I think that's important to note on those 3. The other 3 are a little more self-explanatory: a geographic location, education, training, or experience related to the work, or travel. So a lot of this could be like cost of living changes, or changes in minimum wage based on location. We've had some of those recently, or the amount of travel that the person has to do. If an employer relies on these factors, it really has to make up for the whole pay gap. So the reliance on this has to make the entire pay gap. The remedies for Part 1 include up to 6 years of back pay. So that's up from 3 years. So the 2021 law provided for 3 years of back pay. So that's that money that you would have made had you been paid as much as you should have. So that was increased to 6 years. There's also liquidated damages. You can get reinstated or get a promotion. And then there's also attorney's fees. So that's in court and now as well in our division. If you can go to the next slide. I'm not going to dwell a lot on this slide, but I just want to note that there are other requirements under Part 1. or I guess prohibitions under Part 1. So an employer can't ask about an applicant's pay history. So this one is, I think, I really want to get education out about this because I think this is a common question that happens with employers, I mean, historically. And so just understanding that they can't rely on that. And that's really to not perpetuate some of the historical pay gaps that we've seen. They can't retaliate against folks for asserting their rights under the equal pay law. They can't prohibit people from talking about pay in the workplace or, retaliate against someone for filing a complaint, for example, with our division. Workers may sue get an attorney or represent themselves in court, or they can file a complaint with the division. And I've linked, I think I saw in the comments that, in the chat that these slides were going to be shared. So that link will go to our Equal Pay for Equal Work webpage. And at that webpage, you can see where you can file a complaint there. The only thing I'll note for Part 1 is that it is discretionary, meaning that the division can decide which complaints to pursue and investigate. But we also have a mediation program that the statute requires us to get up and running by July. So I think that that's a good opportunity for people to try to come to the table with the employer and get a resolution, hopefully more quickly and outside of the court system. So now Part 2 is the transparency piece. And this really surrounds when an employer has to tell their employees about a job opportunity and what that posting must say. So one of the misunderstandings I think people have is that there's this requirement that employers must post jobs externally. That's not necessarily the case, but they have to tell their employees, all of their employees, about job opportunities if they're in Colorado. So when they're telling their employees about job opportunities, or when they decide to post those job opportunities externally, they have to include pay, benefits, and anticipated deadlines in those job postings. The pay has to be a good faith estimate of what the pay would be. And so when I think of good faith, I really think of, or bad faith, I guess, I think of the really, really large ranges. So I've seen like $40,000 to 180, and that to me is not reasonable. And I can't imagine a scenario where in good faith they would pay that big of a gap. But the important thing to note there is also that employers can go above or below the range as long as that first initial estimation was in good faith. There's also guidance that I've linked at the end of this slide deck. We call our guidance infos. And so if you go to info 9A, there's a lot more detail about deadlines as well. But for time's sake, I'm not going to get too much into that. The employers must also tell employees who are going to be working with the person who is hired. They have to tell them who was hired, and they have to tell the employees how they can demonstrate interest in future opportunities. And that's just to really encourage people to understand that opportunities exist and understand how to seek those opportunities. Workers may again sue or file a complaint with our division. We are required to investigate these claims. We get probably around 100 claims per month. I can't remember the last number, but we get it's a high volume program. And like I said, we have to investigate it. And I have a great compliance investigator on staff who works these cases. And I think it's a really great way to enforce in this case, because not everybody's going to want to go to court, over a posting that they saw, but it is a great way to enforce, and also a great way to kind of educate employers. We get inquiries through our email, which is also linked on the resources page, so that we can kind of help employers with tough questions as well.
Thanks so much, Ellen, for explaining all of the details and the nod earlier to some of the good news we have to share about how powerful the pay transparency requirements, coupled with the stronger and more enforceable requirements for paying folks equitably, they're doing substantially similar work. And we have some very recent good news about how effectively the Colorado Equal Pay for Equal Work Act is actually working to help close the gender pay gap faster here in Colorado than in comparison to the rest of the states that don't have a pay transparency law in place. There is a Colorado economist who recently did an analysis for the Women's Foundation of Colorado, and he found that since the Equal Pay for Equal Work Act went into effect in 2021, here in Colorado, the wage gap has closed by 7 cents on the dollar. And the other states that followed Colorado's example, and since our pay transparency requirements went into effect in 2021, have passed and implemented similar laws. So these states include California and Washington, while others continue to follow suit. And the California and Washington were included in this analysis as well. And though they haven't had their laws on the books for quite as long, and they don't apply to all employers with employees working in their state, as Colorado's law does apply to anyone employing at least one person in Colorado, they too were seeing faster rates of the gender wage gap narrowing in their states in comparison with much slower progress for the remaining states that don't have any pay transparency requirements on the books. And what this means in real terms for working women in Colorado is that we're earning more. On average, Colorado women saw their pay increase by almost $3,000 annually. And this pay increase that women experience didn't come at the cost of decreases in men's earnings. Men's earnings held steady in the same period of time, and women were paid more for the work that they're doing here in Colorado communities. So this means that women are being paid more of what they should have been paid all along, and we still have progress to continue making. And learning sessions like this help more people understand what employers are required or prohibited from doing, helps workers really understand our rights when we are discussing pay with our colleagues, or when we're looking for new jobs, what we can expect to see in applications, what employers can and cannot do during the negotiation process, and all of that helps to strengthen the impact as well. And as we continue to try to make sure that folks understand their rights and responsibilities with the equal pay law, it really helps when we can share stories about what this has meant for individuals. It's great that we've got numbers showing that Colorado women are earning almost $3,000 a year more since the Equal Pay for Equal Work Act went into effect. But if you have a great story to share about how seeing the posted range in a position that was announced as a job opportunity that helped you negotiate for fairer pay within your employer, or helped you really refine your job search and negotiate for better pay as you are making a job transition, we would love to hear about it. So when the slides are shared later, I can share a link to a survey as well. If you'd be willing to share your story, you can help us raise awareness of the law and help more people feel confident in exercising their rights under the Equal Pay for Equal Work Act as well. And Ellen mentioned that there are a number of resources available through the Department of Labor and Employment's Equal Pay webpage, and I'd really encourage you to take a look at those infos she mentioned about equal pay requirements and pay transparency. And the information shared through the CDLE webpage is detailed, thoughtful, really provides helpful examples and all of the information that employers really need to understand to implement the law in their workplace. And there are really great guides for what job seekers and workers have access to under the law. And non-attorney over here, I tried to translate some of this into lay terms to have a sort of rule of thumb available to complement the much more detailed resources available through CDLE. So I'd encourage you to take a look at the Women's Foundation's Equal Pay page as well, where you can find more of that research and the good news data that I shared, as well as one-page guides, the key things that employers really need to understand about the Equal Pay for Equal Work Act, and what we as working women in Colorado and job seekers need to understand about our rights under the law. So please take a look. You find those guides helpful for you. Please do share them with Junior League members and other folks in your networks as well. We want to make sure that folks are leveraging the equal pay law to the greatest extent possible and being paid what they're worth. Thanks so much.
Hi, Louise. We have a question in the chat. It says, who has the burden of proof in these cases of wage discrimination? Does that fall on the employer or the employee?
So Ellen, that's like a great one for you.
That's a good question. The employee has the burden of proof to show that they're not being paid equally. And then the employer has to come back and essentially have the burden of demonstrating that one of those 6 exceptions that I shared before, that one of those apply, or that the jobs weren't substantially similar. There are a few ways for them to defend these types of lawsuits, but they have the burden to bring those defenses.
Thank you. It looks like we have another question here from Brenda, and feel free to come off mute if you have anything to say outside of these comments, but looks like Brenda's been posting jobs for 5 years, and according to new pay transparency standards and updates with the legislation over the years, are you still seeing folks in Colorado posting jobs without the necessary requirements? And how many fines are you seeing in the state of Colorado?
So I can take that one as well. Unfortunately, yes. I mean, we get, like I said, hundreds of complaints, and we do see all the time that employers are not including the compensation and benefits. Recently, we added in 2023 the requirement that they post anticipated deadlines. And so almost all employers are not, I shouldn't say almost all, a lot of employers are not doing that quite yet. And so we're looking to really educate pretty fiercely on that soon. And I'm glad that you asked the question about fines, because I forgot to mention that on the Equal Pay website that I linked in the presentation, there is claim data that we update every month. And so we have like the total complaints filed, the amount of compliance letters, which is basically us asking the employer to come into compliance. And then we have total fines. So our total fines over since 2021 were 238,000. And you can also see who the employers are and what their fines were on that website as well. I will say, just to add, because I don't want it to be a total bummer, I think employers are incredibly cooperative. A lot of employers that aren't posting these things, when we tell them that they need to be doing it, they come right into compliance. And a lot of them are small employers, you know, who don't maybe have legal resources to be fully on top of things. And so a lot of them really do come into compliance, and some of the bigger employers work with us in trying to make sure that their postings are correct. So I think that it's been great. There just are still employers who are not fully compliant.
Wonderful. We have another question here. For jobs that are technically in multiple states, are they still required to post the wage range for jobs when they post in Colorado?
So if employers have essentially more than one person working in Colorado, and if they have a site in Colorado, they need to post the salary range if they have folks here, even if like if that position is remote, for example. There was an sort of exception that was created that I'm not going to get too into the weeds about because it's very nuanced. But essentially, if there is a Colorado person and if the job can be performed in Colorado, then they need to include that information and post the job opportunity to folks who, to their Colorado employees.
Great. Any more questions? I think that's it. I think we can move on. Thank you.
Great. Thank you so much, Louise and Ellen. That was wonderful and super informative. And we're gonna kick it off next with Kaitlin Altone, who, as I mentioned earlier, will be giving us kind of a higher level overview of family, the family law, and she'll touch on important things to know in terms of the rights and violations, and provide some context behind the need for this legislation. So to give a little background on Kaitlin, she is a senior organizer in the Colorado chapter of the National Association of Working Women. She joined the team in 2019, working to pass the paid family and medical leave. And she now chairs the Family Implementation Coalition and leads the Worker Justice Program. She earned her Bachelor of Arts in Psychology from the University of Albany, and Masters of Social Work, and her Masters of Social Work as well, concentrating in policy, practice, and organizational leadership from the University of Denver. Prior to this, or prior to joining the National Association of Working Women, she got her start in community organizing through issue-based canvassing and local election campaigns. She also has a background in providing mental health services for children with trauma and is an alum of AmeriCorps. She has a commitment to anti-oppression and social justice that drives her work. And she's originally from upstate New York. She now lives in Denver with her partner. So Kaitlin, if you're ready, we'll have you take it over from here.
Yeah, great. Thank you. I will take just a moment to share my screen. Oops. Okay, that should be good. Hi, everyone. Thank you so much for having me. Really appreciate the chance to talk about family, paid family, and medical leave with all of you. Like was said, I'm a senior organizer with 9 to 5 Colorado, National Association of Working Women. So I'm going to be talking to you about FAMLI, which is Colorado's program to provide paid family and medical leave. So many of you might remember, but FAMLI was established through the passage of Proposition 118. So this happened back in 2020. We as voters were able to make this really like historic program happen for our state. And it was really great to see just the like wide breadth of support for this program. We'll revisit this, but just to have it in your mind. So paid family medical leave, what it is and what our program does is it provides paid time off from work for you to care for a new child, your own serious health condition, care for a family member with serious health condition, safe time for domestic violence, sexual assault, stalking, and also to make arrangements if your family member is deployed in the military. So before getting into, the weeds of the program, I just want to ground everyone in why paid family and medical leave is so important. And also just like for some context about 9 to 5 for us as an organization and our members, why paid leave has been such an important issue. And that's because paid leave is really a gender, racial, class justice issue. Most folks have not had access to paid family and medical leave across the country, in our state. But the people who experience the most unmet need for leave has historically been women of color, in part because, women tend to carry a lot of caregiving responsibilities, and also, class and, continued historic oppression. And this lack of paid leave can really have impacts on a person across a lifetime and generationally, both in terms of what their income earning potential is, as well as, at the heart of this, it's our health, it's our families. So I wanted to set that for y'all. And also, I'm not going to get into the whole journey of working to pass FAMLI, but I do want to emphasize that being able to win paid family and medical leave was a really long journey, and it is something that happened due to the power of organized people. There was a lot of opposition to paid family and medical leave. We first introduced this, tried to get it passed the legislature back in 2014. There were years of this. Even, when we got to our trifecta, there was still opposition. And I just want to be really clear that there was not a willingness to pass a program that would meet the needs of people who most need paid family and medical leave, and some of the most vulnerable in our communities. And, in kind of a wonderful way, the fact that we were then able to turn to the ballot and, the voters of Colorado said yes, was a lovely way to win. And we're actually the first state in the country to pass paid leave at the ballot. Since then, we have been in years of implementation, which, is can be a very in the weeds process, but it is also a process that's really important to engage in to ensure that the equity that was fought for in the policy is really delivered. So we've been engaging in that. And then January 1st this year, FAMLI is now fully launched and available. So getting a little bit more into the FAMLI program, what it is, how it works. Our FAMLI program is a social insurance program. I feel like most people might not use that word in their everyday life, that phrase. But social insurance is different from other types of insurance that at least we frequently interact with, whether that's our health insurance, car insurance, those things. Most of those are set up to run for the company to make a profit. A social insurance program is not set up to make a profit. It's set up to serve the community that it's for. It is also tied to you as a worker, not you as a worker for that specific employer. If you think about your health insurance, that might be employer provided. When you change jobs, your health insurance changes. That is not the case. And it also works for you across jobs if you hold multiple jobs, and there isn't that, disruption in change when you change from one job to another. It is taking into account you as an individual and your most recent earning history. Social insurance programs, awesome because the cost is so much lower. It's the most affordable way to run a program like this while also making sure the benefits are adequate for everybody. Our family program, it is administered by the Family Division, which is within the Colorado Department of Labor and Employment. And how we fund family is through premiums, which is a payroll deduction. You're likely seeing this on your paycheck. Employers and employees both contribute to this. So who is covered by family? The answer is most Coloradans are covered by family. The three questions you can ask yourself is, are you a Colorado worker? Have you earned at least $2,500 in the previous 12 months? Do you have a social security number or an I-10? Then you're able to use family. I also want to name that immigration status is not a factor for family eligibility. So if you're a regular employee, then you should already be enrolled into family, and there's no extra step that you need to do until you need to take paid leave. For other folks, non-regular employees, folks who are self-employed, really, anyone who's a 1099, those workers do need to take an extra step of self-electing coverage under family. And they can do that at My Employer Plus on the family website. This is a little complicated. I want to name it, but I won't go too into detail. But there are some local government employees who may not be included in family because of their employer, who is a local government. Basically, due to state law, we can't require that local governments participate in the state program. So they are able to vote to not participate. That only impacts the employees of that local government. But if that is the case and you're a local government employee, your employer has voted to not participate, you can still join the program as an individual. And then you would do the same thing as basically if you were a self-employed person. Cool. 1 second. Okay, I'm going to shift gears a little bit to start talking about what are the benefits of family. I think it's easiest to understand if you think about it in these 4 parts. Each one of these parts, can change, but they all work together for you as an individual when you need family leave. The first is qualifying events. So what is that reason why you need paid leave? Leave and duration, how often you're taking it. So what is the amount of time that you need? What does that look like? Wage replacement, which is the paid part of paid family and medical leave. And lastly, job protection. I'm going to name this last little bit, just in case this does apply to anyone. It's a small percentage of workers, employers in Colorado who have gone this route. But if this is the case for you, if your employer has gone with an approved private plan to provide these benefits, so basically they have to do all the same things. They're just doing it instead of the state program, they're using a different party. They are required to provide all of the same benefits, rights, protections, and that cannot be at any additional cost to workers or with additional barriers. Literally, the only thing that should be different is where you file your claim. Cool. So now we'll go one by one for these. For qualifying events, so why will you need to use paid family and medical leave? There's 4 ways that you might need it. The first is bonding or caring for a new child, and that can be whether through birth, adoption, foster placement. You can take paid family and medical leave during that first year, whether that's through the first year of their life, first year of them being with you. You can take leave for serious health conditions. A serious health condition that you have or your family member has, and you need to take care of them. A serious health condition is any medical, mental health condition that you are under a health provider's care, oversight, inpatient, outpatient. That's pretty broad. But it is different from maybe like sick time, where it's like you have, a short-term virus, which is just like, I need a day or 2 off. You don't need to go to the doctor for that, right? Serious health condition. Safe leave. I'm really proud that our program includes this. You can take paid family and medical leave if you or a family member is the victim of domestic violence, stalking, sexual assault, or abuse. So whether that's, there needs to be a change in where you live because to be living in safe conditions, to get away from an abuser. If you're engaging, with the criminal justice system, or other types of treatment you might need, paid leave can be used in that scenario, or if your loved one is the victim and you need to help them. And then lastly, if a family member is on active military duty or called to duty and there's arrangements you need to make, then you can take time for that. Who can I care for? So family member, I said that a lot. Importantly, we've made sure that there's an expansive definition of who is family. Historically, it's been kind of a narrow definition. So the law itself is pretty explicit about many family relationships, but it's also written in a way that if that family member is not explicitly named, you can still take leave for them. You just need to show when you apply that that person is a family member or is akin to family. The amount, how long you're going to be on leave. So family leave can be taken, you are able to have up to 12 weeks in a year, or a 12-month period. And you can also have an additional 4 weeks in cases of pregnancy or birth complications. That amount of time that's available to you, it will refresh on the anniversary of that last leave start date. So say you were to take leave starting May 2024, May 2025, you're all topped up. And that leave could also be used maybe all at once. Say in the case of a new child, you're taking all 12 weeks, or it can be used over multiple claims. And how you structure that leave, you have a few different options. You can use it continuous, so all at once, intermittent, say it's a health condition that has flare-ups, or reduced schedule. Maybe you're recovering from a surgery and just need to get back to work part-time. You could use it that way too. Wage replacement. So this is the pay that workers receive while on leave. It is paid from the family fund. How benefits are calculated is it is based on a worker's average weekly wage, and it can be up to 90% of that. And it's works as a sliding scale so that the lowest paid workers receive the highest percentage. And if you want to check out what your wage replacement estimate is, as well as check the premiums if you're not already seeing them on your paycheck, they do have a pretty great calculator on the family website. So I recommend that.
Kaitlin, just a heads up, we have about three to 5 more minutes.
Oh, okay, perfect. Thank you. Just about there. Job protection. So folks are eligible for job protection if you've been at that place at work for at least 180 days for when your leave begins. You cannot lose your job for taking family. I also just want to point out that even if you are not eligible for job protection, you're still eligible for all of those other benefits. Cool. Here's just a short little snapshot of when you need family leave, what that timeline looks like, if the leave is foreseeable, or if it's unforeseeable. Both of those scenarios work. And I also want to make sure folks know that if after you put in your claim, if there's an issue, it's fully, partially denied, not what you were expecting, you are able to file an appeal. Oops, that one. And then lastly, I want to mention just some unlawful employer behavior for folks to be aware of. And that if you do experience this, you should go to the family website. You can file a complaint. So it is unlawful for employers to interfere with your ability to take family, regardless of intent. It is also unlawful for you to experience retaliation or discrimination due to use of family. Some resources. This is the contact information for the family division, as well as some partners. And then last but not least, we want to definitely hear from folks who are using family. If you're serving any population, you're in a position where folks are telling you about their family experiences. We'd love for you to fill out the survey. It really helps us be able to advocate for community needs during this first year of the program. So I will stop there. Thank you.
Perfect. Thank you so much, Kaitlin. We are going to do some Q&A. There's a couple of questions in the chat. Stephanie, if you want to spearhead that.
Yes, perfect. Thank you. Okay, let's see. We just got a couple more in, but I'll start. How much time do we have for questions?
About like 3 to 5 minutes.
Okay, wonderful. Clark, is your question answered, or do you need a follow-up on that? Okay, I'll go ahead and ask this. So she heard that family allows you to use sick time, the short-term kind, to care for family members. For example, if your child has to be home from school for a few days, is that something separate or not accurate?
Yeah, that's a great question. So I think that's in reference to a different Colorado law, Healthy Families and Workplaces Act. That is sick time law. You can definitely use it for that reason, to be able to care for your kiddos, family member, home from school. The difference is that by law, it's only up to, I don't remember the number off the top of my head. I apologize. But about a week's worth of sick time hours in a year that employers are required to provide. So that's for those like short-term reasons. But when you have those longer term needs arise, then you can use family. Both laws, super important. And, we need, a patchwork of types of leave available to us as workers.
Absolutely. It's a great benefit. Okay, we have a few more questions. Let's see if you're employed by a Texas-based company but still have a Colorado office, is family applicable?
Yes. If an employer has a Colorado worker, they need to be a part of this program.
Wonderful. Okay, in the first 4 months of this benefit, have the usage of family and the funding been on par with the estimates of cost it will require, running higher than estimated money required or lower? And do you anticipate the cost to employers and employees remaining the same, getting lowered, or getting increased?
Yeah, that's a great question. CDLE would have all the details on this, but I do participate in their stakeholder calls, and they've given some updates. So right now, the program is doing really well, solvency wise. It seems like, while there is an exact number to like compare to, but it does seem like the employer participation, folks who should be paying premiums are. So their actuarials for, which I think is for like the next 10 years, which is far as they can do, is that the program is doing really well, on track financially. And in terms of cost, so right now the premiums are set at 0.45% for workers, 0.45% for employers. That can only ever go up to, I want to say 1.1% by statute. And that also could be lowered. And that will be sort of looked at annually by the division director.
Great. Okay, I think we only have time for, actually, I think that's time. Please correct me if I'm wrong.
I think actually looking at the time, we should have time for at least a couple more questions if
Okay.
any come up.
Thank you. Okay, so one more question here is, if you use family for care of a family member, but then need to use it for your own serious medical condition, how would that work? Can the two run in parallel? And I'm assuming this is in a calendar year or a fiscal year, depending on how this falls.
That's actually a really interesting question. I don't think anyone's ever asked me that before. So in the same calendar year, or actually not calendar year, in the same 12-month period, or any period of time, yes, those are just two different claims. If it comes up where those two things are happening to you at once, it will probably depend on the situation. Like if, say, you're on reduced schedule for one reason already, and then something comes up where now you need to go to just like fully continuous leave for however many weeks, you would definitely have to be in touch with the family division to make that adjustment. But it's the same. So your wage replacement might change because you're taking more leave at that time than you started out, like per week. But I think my understanding is that would be possible to make that switch like midway through a leave.
Thank you, Kaitlin. Okay, we do have another one. How does FAMLI apply to remote workers who are Colorado residents? And I believe you answered that a little bit with the Texas question, but if you could elaborate a little bit more, that'd be great. Oh, you're muted.
Sorry. For remote workers?
Yes. So if they are a Colorado resident but work remotely.
Yes. They would be considered a Colorado worker. They would pay, state taxes, all of that, address of work. They count as a Colorado worker. So that employer does need to make sure that that worker is getting family benefits and is part of the program.
Perfect. Thank you. Okay, I think that wraps it up. Oh, Brenda did ask, how soon will you be auditing employers?
I would direct that question to the family division to get a better picture of that. I can just say for employers using private plans, they have to be approved private plans. So obviously that already happened. For Brenda, there is private plans do have to be like reapproved after a period of time, and there is data and reporting requirements.
Great. Thank you so much, Kaitlin.
All right. Well, if there's no more questions for Kaitlin right now, and we'll have time at the end too, if additional questions come up, we should have a little bit of time to do like an overall Q&A. So if there's not any other questions, we'll go on to Diane, who is going to be sharing with us some practical applications of FAMLI from, again, the employer side as well as the employee side. So Diane is the head of total rewards at the University Corporation for Atmospheric Research, which manages the National Center for Atmospheric Research in Boulder. In her role at UCAR, she's responsible for the design, strategy, administration, and compliance of compensation and benefits programs for all 1,400 employees across the U.S. She has broad experience in both employee benefits and compensation, with significant knowledge of ERISA and qualified in retirement program compliance matters. And she received her bachelor's from Arizona State, and her LLM in taxation from the University of Denver. So thank you, Diane, if you want to kick it off.
Sure. And I am having a hard time sharing my screen. It's telling me I need whoever's on there to stop sharing first.
Okay, hold on. Let's see if.
There we go. Okay.
Got it.
I think I got it. Yeah. Okay, so I'm gonna just go over kind of some practical applications of both FAMLI and EPOA. I have been living and breathing these, I feel like all day, every day, for a long time now, especially FAMLI with the implementation of the new plan. So this is really gonna give kind of tips and tricks. We talked about private plans briefly, and so just kind of give an overview of some things to ask, questions you might want to ask your employer, and some practical applications of this. And I'm going to kick it off with FAMLI. So with FAMLI, there might be a different plan that applies to you than the plan where you go and you apply for benefits through the state. And that would be because your employer has opted out through an approved private plan, or you might actually have more leave options that are going to wrap around or be in addition to leave. So essentially, if your employer has a private plan, you might need to ask them for the benefits information and for the claim, or the plan actually might be administered through a third-party insurance company, for example, a Unum or Guardian or Hartford. So if you haven't received information already from your employer, you should have received a notice probably by the beginning of December. If they opted into a private plan, they're required to give you notice. If you didn't get that or you missed that, then your plan is your employer's likely participating in the state plan. And no matter what, if you contact the state and you request benefits, if your employer has that approved plan on file, they will direct you back to your employer. So no matter what happens, you will get your benefits. You'll eventually get directed to the person who is going to be able to help you. If your employer has their own private plan, they have to be at least as generous as the state family plan. A lot of employers that opted out because we wanted to give more generous benefits. For example, a lot of us are paying full pay rather than that sliding scale up to 60% of pay. However, there were other nuances that the employer plans have to follow. You can actually take time off under your employer's private plan, even if you already took time off under another employer's plan. And so that's something that we're actually seeing in practice. We'll have employees join us. They may have had a child within the past 12 months. They took time off through their employer's plan, and they are able to take that additional 12 weeks or 16 weeks off under our plan, even if they had 12 weeks off. Same thing that we're also seeing people that are leaving the state, if they've receiving benefits through the state plan, once they're approved, even if they're not living in the state anymore, they're still able to receive their full amount of benefits. So if you are in one of those unique situations where you're changing employers or even moving out of state, ask about what will happen with your benefits. If your employer is participating in the state family plan, so you're going onto the state portal to request your benefits, your employer may still also provide additional pay to top off your wages. So it could be considered what they call a wraparound plan or a top off plan. And again, they could pay it to you directly or through a third party. So as you're realizing you need leave, besides just going to the state and asking the state, ask your employer what other types of leave are available. Your employer might also have additional types of leave that may be used before and after your family leave. So that could be like PTO, that could be, some companies have something they may call extended sick leave that you're allowed to take in addition to your family leave. However, under the state law, they can't require you to use any leave before you start to use family leave. So if your employer is telling you you need to take X, Y, or Z leave before you start using family, that is not accurate. They're not allowed to require you to do that. They may allow you to if you want to, or they may not allow you to. They may require you to go straight to family. When it comes to getting family paperwork, we're seeing a lot of issues just getting this in time. And so if you are going to be, if your employer is not participating in a private plan, you're going to be going to state, and that's probably pretty streamlined on the state portal. It's very clear process that walks you through. Your employer is not supposed to have paperwork or a process that is more onerous than the state's process. And so in theory, this should be just as easy. In reality, employers are still learning, they're still implementing. And so sometimes it takes a couple of emails back and forth to get the right paperwork to start the process. Either way, your request will be submitted to your medical provider. And what we're seeing is that they're taking a long time to get this, depending on the volume and how their practice works. And so, the pay for family in the private plan should be retroactive to your first day of leave, assuming that you gave notice within the time that you were required to. But again, sometimes we're seeing difficulties with medical providers getting the information. Some big providers like Kaiser have a formal process where they will send you to a forms department to handle leave requests. And that is taking a long time. To give an example, Kaiser has two different groups. One's giving FMLA paperwork, one's giving family paperwork, and the family paperwork group is just taking a lot longer, I think, because of the volume of the requests. And then if you participate in the state plan, you don't also have to give that information to your employer. So if your employer asks for it, they're not entitled to a copy of it if they are not administering the family plan. However, they can still ask you for a fitness for duty form to return to work, and that's perfectly legitimate. So another thing to keep in mind, and I think this goes back to one of the questions we had earlier, is that family interacts with a lot of different leave laws. And so sometimes it's going to get complicated. Sometimes you're going to win the lottery and you're going to get a lot of time off, whether it's paid or not, just depending on your exact situation. So we talked already about the Colorado Healthy Family Workplace Act. And so essentially, if you are a worker in Colorado, you're going to accrue 1 hour per 30 hours worked, up to 48 hours per year. This is even if you're in a job that's not eligible for like paid time off or vacation time. It is a law that you have to get this work, this sick time, and it can be used for a whole host of reasons. If you search for Colorado HFWA, the reasons will be on that page on the state website. But if you are absent for less than 4 days, you don't need to provide any documentation. Most employers, my organization and most people I've talked to, we aren't requiring any sort of paperwork. It really, even if your absence lasts longer than 4 days, but we are allowing staff to use that. So a lot of times people will use this first if they don't think that their leave is going to be longer term. They don't want to go through the hassle of getting paperwork for family. However, again, if there's something that you need leave for that falls within one of the reasons of family, you are not required to use this leave first. This is just additional leave that you are entitled to throughout the year. Family also interacts with the federal time off law, the FMLA law. And so the FMLA leave is unpaid leave, although there might be other paid leave programs in place that your employer runs. So generally, this is going to run concurrent with family. So if you are working with your employer, regardless of whether your employer has a private plan or has participated in the state plan, they're also required to put you on family. If they are, given notice that you have, you're taking leave, you have a eligible reason for leave that falls under family, they're required under that law to put you on FMLA to make sure that you get the federal job protection. And so they will probably still be reaching out to you about this. In reality, the practical application is that you have your job protection under family, you have your job protection under FMLA, and if the two periods align, you don't need to think twice about it. However, there are really unique situations where the two periods of job protection might not line up. And so you might wind up with 24 weeks of job protection, not just 12. And so an example of that is that family, your job protection is going to kick in at 6 months after hire. And I'm sorry, that's a typo. That should have said 6 months instead of 6 to 12. And you get your benefits from day one, your time off pay. But with FMLA, you're not eligible until at least 12 months in if you've worked 1,250 hours during that 12-month period. So if you need to take time off when you first start with your employer within that first 6 months, you're going to get your 12 weeks of family job protection, where you're required to be reinstated to, your same or substantially similar job, unless there's a legitimate reason of a reduction in staff that would eliminate your position. However, with FMLA, you're not eligible for leave. So you would really not be eligible until 6 months after you use your family leave, and you would be getting double leave. So I think that's just something to keep in mind if that happens to you, if you happen to have a situation where you need a lot of leave, whether it's two different situations, you take time off to have a baby, and then you have your own serious health condition, or you have a serious health condition of a family member that you're taking care of, you will have that job protection. So I think it's important to ask your employer about FMLA, and we'll get to a slide with some questions to ask in a moment. And then ADA accommodations too can provide you with some time off if you need that beyond what family grants you. Typically, we see that with staff who need a reduced work schedule and they're out of paid time off, and they're out of job protection. It's a very complicated process, and the law essentially says that if it doesn't result in an undue hardship to an employer, that they have to provide the accommodation to you. So it's kind of a convoluted way of identifying whether that's an undue burden or not for your employer. But essentially, you would need to request the accommodation and work through with your employer to see if that is reasonable to get you that intermittent leave. So again, family runs out, you may still have other options like FMLA or ADA or PTO, vacation, sick time. So one thing that I've noticed a lot of our staff is that not everyone's familiar with the new law. So sometimes you might have to educate someone and just say, hey, I don't think this is right under the law, or, can you tell me what I am supposed to receive under the law? And if in doubt, always ask your HR group. A lot of supervisors just don't get the information flow down from HR. Ask if you have a private plan, or if you would apply for benefits through the state. And ask, what additional leave is permitted beyond family. Some employers are going to give additional time for parental leave, or, again, they might have additional sick time that you can take. Also ask, what type of pay is available on top of family, because unless you have a private plan that pays 100%, you're not going to receive 100% of your wages, but you may be able to supplement with vacation pay or sick pay, or there may be some other plan that your employer has. If you have to report your time to your employer, ask about that. Ask, how do you report your time off for family? Because you are not getting pay, unless you're receiving pay from additional program, you're not getting pay from your employer during that time. So if you have like billable hours, or you're in government contracting world where you report your hours, ask how to report the time off you have for family. Ask how pay raises are going to be handled while you're on leave. Leave you take for family should not impact your pay in any way. And so if you have merit increases coming up in the middle of your continuous leave, ask your supervisor or HR how that's going to be handled, because again, you shouldn't be negatively impacted. It just might be that it's applied retroactively. Same thing with pending promotion. You should not be negatively impacted by being on leave. And so if you think you have a promotion that is going to be upcoming, ask your supervisor about what will happen. And then again, ask about additional pay options. Ask, specifically, is there FMLA protection available when my family expires if you need more than those 12 weeks off? And ask about their process for the ADA accommodation. Make sure you know which paid holidays fall within the family period, because those should be covered by your employer, since technically it's not a sick day off or a family day off. And then ask about a fitness for duty certificate. I'm going to switch topics to equal pay for equal work, and I'm going to try to breeze through this in the interest of time. I know we're getting close to the end of this here. So the Equal Pay for Equal Work Act in practice. So pay for similar jobs can be different. And this is something that we see a lot of employees asking questions about. Well, you know, my coworker and I have the same job title. Why do we have different pay? And so as long as it's the pay difference is based on one of the approved factors, such as performance, relative experience, seniority, that is okay. So jobs can have the same title, but they can encompass different responsibilities. For example, at my organization, not all supervisor jobs have supervisor in the title. And so we can have people in the same job profile, but one person might be supervising 3 other staff and one person not. And so that would be a legitimate reason for a pay difference. And then performance-based increases over the years can really add up and create pay differences. But again, there's a very, very narrow list of reasons why pay can be different. All job postings, including your internal postings, have to have your salary range or hiring range included. And so one thing that is helpful as well, if your company doesn't have a ton of pay transparency and doesn't have a ton of things posted for staff to see, you know, who's in what salary ranges, review these internal job postings and compare yourself to jobs that you think are very similar to yours. If you are wondering how you're paid or how your pay compares, that's one way you can kind of see that. Also note that past salary history can't be taken into consideration when setting salaries. So if you are either negotiating as part of a job promotion, if it's, you know, a competed promotion at your company that you applied for, or it's at a new company in Colorado, don't request your current salary and be matched, because an employer isn't allowed to take that into consideration. But you can tell them what you're looking for. So say I'm looking for $75,000, not I'm currently making $75,000. And if you're a manager, don't request or research a candidate's current salary amount. I know where I've seen that in my organization, it always comes with the best intention because managers are trying to increase that hiring amount. But again, we're not supposed to be doing that. And so instead, tell whoever's working on your salary, you know, what you hope to be paid. If you are negotiating your pay, name specific reasons. You will be more successful at this under the law, because if you talk about experience, education, your performance, if you have a counter offer, if you are negotiating your pay and you talk about a salary range or a hiring range on the external job posting, use caution saying that directly. There are some laws, some antitrust laws out there about wage fixing, and a lot of employers, especially your larger employers, are going to use market data that they receive from paid vendors. This data is anonymized. It's you know, there's a large number of employers that are contributing information, and the third party is consolidating and averaging all that data to make sure that we don't run afoul of the Sherman Antitrust Act. And so they might deny that straight out. So again, rather than specifically stating, well, I saw this in this job posting, you know, I saw they're hiring in this range. Again, use that as for your own information as you're researching what you think your job should pay, what you think a new job should pay that you're applying for. But then go back to the language of I'm asking for $75,000, not, you know, Google's paying $75,000. Also know a lot of organizations, especially bigger organizations, are performing pay equity studies. So I think that's something that, you know, you can ask about. Results typically aren't going to be shared with staff because of the implication that this study has on minimizing damages if there's a claim under the Equal Pay Act. However, the issue should be resolved individually. And so I think it's fair to ask if there's any information about that. And then just something else that, you know, we've kind of noticed, supervisors generally only have access to pay for their direct and indirect reports. So if you're talking with your supervisor about your pay, they might not have the full picture. If you had been talking, you know, let's say you have a friend in the same job who works on a different team and they're making more than you and you don't know why. that it may be something that your supervisor might not have the answer to, because they might not be able to see anybody else's pay except for those who are reporting to them. And so at that point, it's always better to go to HR or ask your supervisor to go to HR to help identify how the pay is comparing. There's a couple other pay laws as well that are going to interact with the Ensuring Equal Pay for Equal Work Act. So the EEO has several different pay laws: the Equal Pay Act, Title VII of Civil Rights, the Age Discrimination Act, and the ADA Accommodations Act. And so these all relate to pay equity. They are going to require pay equity for a broader list of reasons. So you're going to receive protection under the EEO laws based on race, color, religion, sex, national origin, disability, age, and genetic information. Whereas the Colorado law protects gender identity only. However, within that broader protection, those broader protected classes, the factors for setting pay differences are going to be a little bit more broad. But again, there cannot be a discrimination for one of those reasons. So even if you think that there's you're a member of a protected class under one of the EEO laws, that could be a reason to consider whether you are being paid appropriate if there's a discrimination issue going on as well. There's also FLSA and the comps order. These don't necessarily relate to pay equity, but they are pay laws that are in effect that could potentially impact your pay. I know a lot of employees also have concerns about whether they're exempt or non-exempt, and I know a lot of people want to be exempt. However, there are laws about who can and can't be exempt, and they get kind of strict. And so sometimes there will be people that are seem like they want to be exempt from the overtime rules and exempt from reporting their time that are not going to be we also have a few other pay related laws that are going to touch on pay equity, such as kind of the timing, what deductions can be taken from your check. USERRA, which relates to military armed forces leave. FLA and FAMLI also have laws about reinstating you at your job, your current pay rate, making sure your annual pay increases are not impacted by the leave you took. And so none of those should impact your pay negatively. Thinking about the Equal Pay for Equal Work Act, some questions that you can ask are, what's the salary range and hiring range for the job or the promotion that you're being offered? There is a difference between a salary range and a hiring range. Not every company is going to use this terminology the same, but in general, a salary range is going to be the range for the entire job, whereas a hiring range is going to be more narrow. And I think I had that on the next slide about navigating job postings. However, if you're looking at a hiring range, it is more likely you're going to get an offer or be able to negotiate an offer towards the top of that. Whereas a salary range, if that encompasses the pay for the job, no matter how long you've been there working in that particular job, you're likely to be in the bottom half of that salary range when you're hired in. You can ask your supervisor or HR what factors were considered to set pay. If my pay is different from my colleague. This can be tricky to navigate in all reality. Sometimes it's hard for a supervisor to articulate because they would then have to inform you about your colleague's performance and how that compares to you. So for privacy purposes, they might not tell you specific things. However, they should be able to give you enough information and be able to say, yes, your pay was compared to your peer doing the same work, and the pay differences were due to the factors that are outlined in the Ensuring Equal Pay for Equal Work Act, even if they won't give you specifics due to privacy reasons. you can also ask your supervisor for a copy of your job description. I always think that's a good idea so that you know what they think you're doing. And then you can use that to compare yourself. If you're talking to your peers, you have a better understanding of, what your job should entail. Always ask where you can find more information about your company's pay program, if things are posted on an intranet, or if your supervisor knows, or if HR might know. And then another question I always like employees asking their supervisors is just, what are the skills, the duties, the responsibilities required at the next higher level? How can I work on projects? And I like this one too in the context of the Equal Pay for Equal Work Act, because if your supervisor starts telling you things that you're already doing, that arms you with knowledge that, hey, maybe I'm not being paid appropriately for what I'm doing. And that can open up that conversation and make sure that your pay is equitable for the duties that you're being asked to perform. And then just a quick overview of reviewing job postings when you're job searching. Understand the company's total compensation philosophy. So besides cash compensation, what are they going to offer? Time off, how much time can be rolled over? What's your maximum accrual? What's the payout look like? Are you in a state that requires payout of unused PTO? Do they have family leave? Do they participate in the family plan? Do they have their own private family plan that pays more? Ask about your various medical benefits, bonuses, equity, within equity, how liquid is it? What's the vesting schedule? Same vesting schedule question on retirement. Back to that hiring range versus salary range. I think that's something that you can ask as you're navigating the job interview process and working either with the recruiter or with the hiring manager. Is the amount listed the hiring range or the salary range? Again, if it's the hiring range, I'd always say try to negotiate towards the top of that if you think you are very qualified for the job. If it is a salary range, expect to be offered somewhere in the bottom half and try to get that closer to the middle. And then just on negotiation, talk about any lost wages or bonuses that you might have and any competing offers you might have. And that is the last slide that I had. Do we have any questions?
We do. We have one question here in the chat, and thank you for that information. It was very informative, and I already feel empowered by all of the presentations today. One of the questions in the chat so far is, as an employer, if you have an employee on family leave and you hold their position, then they don't return when they were supposed to and never return, what are the options for the employer, and does that person still receive the full benefit?
Let's see, I'm trying to parse this out here. So essentially, they were on family and then they just never come back from leave. They receive the full benefit. If they are, if you have your own private plan, right, and they quit, they're no longer your employee, and so you don't have to pay them as of their last day of work. I don't think anyone, if they have a full-time family leave, would quit before they run out of that paid time off under family. If they're receiving benefits from the state, those benefits will continue to be paid even after they terminate. So if you decide to quit your job, you're really unhappy and or you got a new job, if you're receiving benefits under the state family program, the state's paying them directly to you. It doesn't matter who you're working for because you've been paying into that insurance premium on your paycheck, and so you'll still receive them even if you're not employed anymore.
Perfect. And I'm actually curious, are you seeing or hearing of any decreases in short-term disability because of the family being implemented?
So a lot of organizations, I would say almost all have, well, I can't say that for sure. A lot of organizations have kind of modified their short-term disability program to essentially be the family program, right? So for example, a lot of us with the private plans, we had our own private short-term disability, which was more of a wage replacement, and that has gone away in lieu of the private family plans. I think some employers may still have short-term disability plans, but the way those plans are written, there's usually a maximum of like 12 weeks of leave, and they generally, you can't have any other wages that you're receiving. And so if you're receiving wages under family, you're not really going to be eligible for short-term disability again, unless it's wrapping around. And so I think that most employers that have a separate short-term disability plan, they likely decrease the amount of money that they're paying out, so that the state plan is paying part of those wages now, and then the short-term disability pays the other plan up to a total of 100% of wages. And then after your 12 weeks of family are up, that's typically when your long-term disability is going to kick in, which would be a separate plan.
Okay, thank you. We have another question from Natalie. Her employer has asked that she apply for and collect family as a Colorado resident for a California-based company. They said that they will pay the difference in pay after family to make up the delta for her full salary. Is that a typical practice?
I would say that's a typical practice of a generous employer. Not all employers are going to be that generous, especially those that are based out of state. Either they're not going to know much about the law, or they're not going to bother to do those wage differentials. So yeah, if they are not a Colorado-based employer, I think it's typical, again, if they're trying to be generous and get you 100% of pay for the leave.
Great, thank you. I think that wraps up the chat questions. Does anyone want to hop off mute, or anyone else have any other questions for Diane? I don't think so. So thank you for your time today. Do we have anything else to go over or close?
Yeah, just if anybody has any additional questions for any of the speakers that have come up, since the last couple presentations, that kind of covers anything or everything. Whatever extra questions you guys have, we do have a couple more minutes. And yes, I'm seeing the question of, will the recording be shared along with the slides? Yes. Everything will be shared, as well as if any of the speakers, if any of you have additional slides or websites or anything that would be helpful that you wanted to share, we can feel free to send that to us, send that to Clark, and then we can send that out along with the slides. And one of the comments in the chat is, thank you. This has been one of the most impactful trainings I've been to lately. So that's super nice, because this really was great. So thank you all for helping educate us on all of this. It's been wonderful. So if there are no more questions, we just have a few additional slides, some follow-ups of making sure you're registered to vote. There's a link here to find your legislator, so you know who to write some kindly worded emails to, promoting our kind of following up on our legislation that we've been supporting, and anything else that anybody else has to share or say before we sign off. All right. Well, I think that's everything. Thank you, everybody, for your time, and everybody have a great night, and we'll see y'all soon.